Chair, it is 4 p.m.
It is 4 p.m. and so as chair, I'm calling the meeting of the Board of Building Regulation Appeals to order. Recording secretary, please call the roll.
Thank you, Chair. Board Member Gordon,
Present.
Board Member Miller,
Present.
Vice Chair Lawson,
Present.
Chair Cooper.
Present.
Let the record reflect that all board members are present.
So remote participation under AB 2449. We have the Zoom going. We're good on that? Okay. So we have draft minutes from January 15th of 2025. That have been reviewed by the board. Does anybody have any changes to those minutes?
No change.
Nope. Looking for a motion? I'm looking for a motion to approve
Approve the minutes for January 15th.
Second motion.
discussion. Been approved and seconded to approve the minutes from January 15th. All in favor?
Aye.
Board members.
Open it for public comment.
Yes. The recording secretary, do we have any public comment on item 3, approval of minutes?
You are in the chambers and wish to make a public comment, please raise your hand. I am not seeing any members of the public present.
So that public comment is closed. Now we're taking public comments on item 4, which is non-agenda matters. This is the time when any person may address the board on matters not listed in its agenda, but which are within the subject matter jurisdiction of the board. Recording secretary, can you figure out if anybody's here and provide some instruction?
Thank you very much, Chair. I am not seeing any members of the public present in the room, so you can close public comment.
So public comment on these items is closed. Now we're moving to the first scheduled item, which is an appeal. And I had a little clarification I want to start out with, which is sort of a couple of questions seem to be in front of the board. And so what is the jurisdiction of the board in this matter?
So you are able to review and either approve or deny any decision that is under my jurisdiction as chief building official.
Okay.
So because code enforcement is under my purview, the decisions that have been made here will both be under your purview to approve.
So this appeal hearing is now in session. Each party will have an opportunity to be heard to present relevant information. The scope of this hearing is limited to the issues raised in the administrative notice and order and supporting staff report. Please present only relevant facts that are applicable to this matter. The record may include written submissions, staff reports, exhibits, testimony, and any argument offered during this proceeding. The format for today's hearing is as follows. The city or department will present its case, including any evidence. The city will respond to questions or comments from the board. The appellant will then have the opportunity to present their case for up to 25 minutes. Appellant will respond to questions or comments from the board. At no point will the city or appellant address each other directly and can only address the board. So you're talking to us. We will then open the public comment period. Board will then have a final deliberation and vote. The findings and determinations of the Board of Building Regulations Appeals shall be the final decision of the city in this manner.
Thank you, Chair. So prior to beginning the testimony, I will go ahead and administer the oath. Will the appellant and representative for the department please raise their right hand? Do you affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth?
I do.
Yes. Chair?
Okay. So the official title of this is Response to an Appeal of an Administrative Notice in Order to Vacate for Property Located at 801 Tupper Street, number 806, Santa Rosa, California, 95404, application 009202, 048. So I guess we're starting with Cassidy Anderson presenting for the city.
Just so you don't have distractions. And then I have a quick question. Oh, share my screen. I think I see it, but.
Okay.
Oh. All right. So my name is Cassidy Anderson, Senior Code Enforcement Officer for the City of Santa Rosa Code Enforcement Division. I will be using some slides, but it'll be primarily for photographs. But I am gonna kind of stick to my chronology for the most part. So my name is Cassidy Anderson, Senior Code Enforcement Officer for the City of Santa Rosa's Code Enforcement Division. My duties include supervising the Code Enforcement Division. I'm a certified code enforcement officer through the California Association of Code Enforcement Officers and a certified building inspector through International Code Council and possess over 12 years of continuous experience in the code enforcement profession. I'm authorized to investigate, inspect, identify, and act on conditions of violation upon private properties. I'm thoroughly familiar with the drafting, adoption, interpretation, and enforcement of municipal codes and other incorporated regulations. I have personal knowledge of the facts stated within the staff report, and if so called, can and will completely testify thereto. So just a little bit of background about this property. 801 Tupper Street, 806, was built in 1970. It's a multi-family high-rise apartment building adjacent to Burbank Gardens Preservation District. The property is a 14 floor, approximately 140 unit senior housing complex. The property is owned by Bethlehem Towers Affordable LP. The tenant of record during this action was Sally Steinhardt, hereinafter referred to as the appellant. Since 2018, the subject property, Unit 806, has been the subject of numerous recurring code enforcement complaints and has a documented history of sanitation, lack of required egress, trash and debris, and infestation violations stemming from a chronic failure to adequately maintain the interior of the unit. On December 2nd, 2024, code enforcement received a complaint stating hoarding and pest infestation. So verbatim what the complaint was.
I'm sorry, could you just say that? last
So
sentence again?
verbatim, so real quick, yeah, okay, so hoarding and pest infestation.
I'm sorry, could you just say this, the complete sentence? I was taking a note and I missed it.
So actually, you're supposed to talk to us.
Oh, I'm sorry. I would ask that the code enforcement officer please repeat that last sentence because I was taking notes and I missed the complete sentence.
So can you repeat the complete sentence of the complaint?
Yes, hoarding and pest infestation. On December 9th, 2024.
I'm sorry, I
sent
didn't
a notice.
hear the date. I didn't hear the date of the complaint.
Here, let's do this. There we go.
So I believe it, you said December
December 2nd, 2024.
2nd, 2024, reporting.
On December 9th, 2024, I sent a notice of complaint, consent to inspect letter. On December 30th, 2024, I received a call from Adult Protective Services APS worker Emily Arizu, and we scheduled a site inspection for December 31st, 2024 with the appellant. The inspection was confirmed via email with both the appellant and Ms. Arizu. On December 31st, 2024, Ms. Arizu and I met outside the unit and knocked on the door for several minutes, but received no answer. I also attempted to call the appellant, but again, received no answer. And please bear in mind, I'm skipping around a little bit and just kind of going with the highlights I feel like are important. After the attempted inspection, I debriefed with Ms. Arizu and the on-site property manager, Mary Nunez. We discussed what meaningful and substantial progress would look like. Ms. Nunez stated that the appellant had requested sorting bins in the hallway to sort her refuse into trash, compost, and recycling. Management denied the request. Management offered, in an effort to help the appellant due to her shoulder injury, to clear or haul away one trash bag per day if she left the bag in the hallway. Ms. Arizu stated that APS would be willing to supply garbage bags to the appellant. On January 15th, 2025, I conducted an inspection of the unit along with APS worker Emily Arizu. So I'm going to go for the site to the site inspection photographs. Immediately upon entering the 8th floor hallway from the elevator, a foul odor could be detected from the central hallway. I observed trash throughout the unit, rotting food in the kitchen. The bathroom was filled with items and the shower was blocked off with a bike and other personal belongings. So there's the bike. Previously, there's the blocked egress, rotting food within the kitchen. There was a narrow walkway from the kitchen to the living room with personal items stacked high against the walls. The bedroom was barely accessible with a small clean space where the occupant slept. There were fruit flies, fecal matter from flies or other pests along the ceiling, lights, smoke detectors all throughout. Multiple discarded food storage cartons had been chewed through by rats and there were rat droppings throughout the unit. Staff determined that this was a level 5 severe on the clutter hoarding scale based on the scale provided by the Institute for Challenging Disorganization, ICD. So just some photographs of my general inspection on January 15th, 2025. On January 23rd, I sent a notice of violation letter to both owner and tenant. On February 4th, 2025, I had a phone conversation with the appellant regarding the NOV received. The appellant stated that the infestation was the owner's responsibility to abate, which I agreed with her. The appellant was adamant that she had no responsibility in the matter and that she was unable to clean the unit due to her perception of the dangers rats pose to humans from urine droppings, etc. She stated her shoulder injury / surgery further prevented her from cleaning. After a circular conversation with no common ground achieved, I advised the appellant that I would be requesting that Bethlehem Tower retain the services of a licensed exterminator and provide a report of recommendations to me. I followed up with Bethlehem Tower via phone and mail and copied the appellant. I established a 1-week timeline with the directive to determine if an infestation exists, and if so, requested the following conditions to be met. Identify the pest vermin involved, provide recommendations on actions required to abate the violation. Number 3, provide recommendations on PPE or BMPs, personal protective equipment or best management practices required to clear away personal items, rodent harborage, etc. Provide recommendations on the prevention of reoccurring infestations and provide any other recommendations from the licensed exterminator. So this is the email that I sent to Bethlehem Towers. On February 14th, 2025, Bethlehem Towers management forwarded me an exterminator report from rats to roaches. So there's the face sheet. And I understand these are hard to read, so I'm going to hit the highlights. The report stated that the infestation was severe and consisted of rats, cockroaches, flies, and possibly bed bugs. The report further stated that the unit was extremely unsanitary and that, quote unquote, in order to perform pest services inside Unit 806, all garbage and waste must be completely removed. All doorways and pathways through the unit must be clear. All appliances, electrical outlets, switch plates, and sinks must be fully accessible. The floors and surfaces must be clean. No rotting food, filth, film, mysterious liquid, or foulness of any kind should impede the work or staff of maintenance technicians. All staff, vendors, and management should have sanitary space to perform work and inspections. Lastly, the report stated, so farther down the report, recommendations our company have made to prepare the unit for service have been ignored by the tenant. Requests by staff to improve sanitation within the unit have been met with verbal abuse and raised voices. As far as I can tell, the tenant refuses to accept any fault for the current condition of the living space and blames all problems within the unit on the building itself or the incompetence of building staff or myself. On March 3rd, I sent a revised notice of violation letter clarifying owner and appellant responsibilities with the recommendations provided in the extermination report. So there's my revision. And really, the main revision that I made, I'll itemize out in a moment, was owner and tenant responsibility. The following revised language and deadline of March 17th, 2025. So to the tenant, comply with recommendations from exterminator report from rats to roaches, ensure, which I attached, ensure all trash is removed, appliances, kitchen, bathroom, and outlets are fully accessible. Number 2, show substantial progress of removal of trash and debris every 2 weeks, starting with open containers and rotting food. Remove items from the shower to have a fully accessible shower. So number 4, schedule reoccurring compliance inspections to ensure manageable progress. To the owner, once substantial progress is made in the unit, clearing of debris, rodent harborage, and rotting open food, you are directed to call an exterminator and provide a report to code enforcement of recommended extermination plan. Part of the reason why I just want to clarify, we knew that once the debris was removed, there would have to be a re-inspection. So we didn't want to go straight to extermination after that. I wanted a new report to authorize extermination. So I just wanted to clarify that because I would have had that question. On May 22nd, 2025, I conducted an interior inspection of the unit and photographed the conditions. So I'll scroll through my photos and read at the same time. I observed that the unit was substantially worse than the January 23rd, 2025 inspection. There was a layer of trash covering the floor in the entryway and spilling out under the door into the hallway. I'll show that at the end. More of a rotting foul smell and odor, which could be detected from the 8th floor outside the unit. The bedroom door was harder to move through as personal items were stacked behind it, and in order to gain entry into the bedroom, I had to pass my body through sideways and force the door open with my body as the door was incapable of completely opening. So there's the kitchen and the bathroom. So up here is the bathroom with the bicycle blocking, new box, more rotting food. This is the central hallway area. This is the kitchen area. This is the bathroom, which in previous photographs, there wasn't as much. Now there's significantly more items stacked along the wall. So this is the kitchen area. You'll notice the oven is inaccessible. This is the small pathway out to the slider. And this is just my vantage point, like walking through. This is the walking through, and then this is more of the unit. Oh, I think this is the bedroom area. Pardon me. Okay. So this is the clear area that the appellant includes her bedroom area. And then this is the notice in order to vacate that I posted. And then you can see down here, there's some stuff coming out of the door. Okay, on June 5th, 2025, city staff had a meeting with Bethlehem Tower Management to discuss a long-term collaborative effort to resolve, and then, sorry, this is the notice in order to vacate that I posted. So Bethlehem Tower Management to discuss a long-term collaborative effort in resolving the public nuisance issue and infestation issues affecting the 8th floor. Bethlehem Tower Management informed the city that they were pursuing eviction and that they had referred the matter to their legal counsel. On June 6, 2025, I received an email with an appeal to the notice in order to vacate from the appellant. And so this is the first appeal. On June 9th, I received an email from the appellant with an amended appeal attached. The appeal was considered timely and the city accepted it. On August 27th, 2025, I received a complaint and sent a follow-up email to Bethlehem Tower Management requesting a status update. Management replied that the appellant no longer resided at Bethlehem Tower and that the sheriff lockout occurred on August 20th, 2025. They further stated that they were working on arranging a date and time to allow the appellant an opportunity to collect her belongings. And I know I'm jumping around, and I apologize for that. Just gonna stop sharing. So analysis, the appellant presents several arguments in their appeal of the notice in order to vacate. Each of these arguments is addressed below, followed by the city's counter position. So item number one, listed as 2 and 3, the amended appeal of Sally Steinhardt, submitted on June 9th. The tenant who has resided in apartment 8, this is Sally's position, and then I'll say the city's position. Amended appeal of Sally Steinhardt, the tenant who has resided in apartment 806 since October 2015 on the 8th floor of 801 Tupper Street, Santa Rosa, a 14-story apartment building for very low income elderly disabled adults, also known as Bethlehem Tower, in which building has been infested with rats from the colony living within its walls for an extended period of time, with the knowledge of and due to the active and intentional neglect and intentional concealment of the infestation from prospective and existing tenants by the owners and managers thereof. City's position. The City of Santa Rosa Code Enforcement Division noticed both the owner and the appellant on January 25th, 2025. The NOV delineated responsibility between both parties. The appellant was directed to clear trash and debris every 2 weeks, beginning with open containers and rotting food items. Code enforcement then sent a revised NOV on March 3rd, 2025, indicating the appellant's responsibility to comply with the recommendations from the exterminator report. The appellant was directed to show substantial progress, reoccurring progress inspections every 2 weeks, to provide required access for licensed exterminator. The city determined that the appellant was ineligible for relocation benefits due to the fact that the infestation was substantially causing and contributing to an infestation to adjoining units on the 8th floor due to rotting food, trash and debris, and other rodent harborage throughout unit.
Excuse me.
Regarding the alleged claim,
You get to do her
I'd
first.
just like to
And then
know
you
where
can
she's
respond.
reading from. I'm addressing you.
Okay. There was a report that.
I know, but is there a page number?
You have a page number?
I can go back to sharing. I don't have, oh, it's 7 of 10 on my staff report. Okay. I'm gonna
Hold on for
continue.
a second. I'll take
Okay.
the photos. All right, you ready,
Okay.
Sally? Are you ready, Sally?
So this is towards the beginning? Is this? towards
Page
the-
7 of 10 of the staff report.
All right. Yeah, the city determined that the appellant was ineligible for relocation benefits due to the fact that the infestation was substantially causing and contributing to an infestation to adjoining units on the 8th floor due to rotting food, trash, debris, and other rodent harborage throughout the unit. Regarding the alleged claim of active intentional neglect and intentional concealment, code enforcement has no knowledge of this claim. Prior conversations with management indicate that Bethlehem Towers responds to complaints from tenants within the unit and has a contract with a licensed exterminator on retainer that provides services once per week, once a complaint has been received by management. Bethlehem Towers has demonstrated compliance and proper documentation to substantiate this. Number 2, and this is item 4 on the appellant's amended appeal. The appellant's number 4. Tenant Sally Steinhardt does not protest the finding that Bethlehem Tower is a substandard building, California Health and Safety Code 17920.3 and 17920.3 A12, and the owner is the responsible person because of a long-standing rat infestation due to inadequate garbage storage and removal facilities, as disclosed to me by Senior Code Enforcement Officer Cassidy G. Anderson. She told me rats climb up the garbage chute above a large open bin, which is full of plastic bags full of garbage, and thereby gain access to the between apartment air spaces, which contain plumbing, electrical and communication wiring, hot and cold water pipes that provide by gravity heating and cooling from a boiler and chiller on the roof to each apartment, and which pass through openings in the drywall into the apartment, and high voltage wiring that pass through openings in the drywall to the electric oven stove. I do protest the factually unsupported suggestion that I, a tenant, was in any way responsible or contributed, much less caused or substantially contributed to the rodent infestation anywhere in the building. I have lived on the 8th floor for almost 10 years, during 7 or 8 of which I did not know there were any rats in the building until my tidy neighbor told me that she had found some living in her closet and put everything in thick plastic containers. We compared notes and realized that the sound coming from above the ceiling every night were probably rats. The city's position. As stated previously, Unit 806 has a severe rodent, cockroach, and fruit fly infestation. After inspections were performed on adjoining units, I confirmed evidence of rat infestation. The notice to vacate dated May 22nd, 2025 for Unit 806 does not address or have any merit regarding the trash chute or dumpster. This matter has been previously addressed by code enforcement staff and continues to be maintained by the retained exterminator. Rat traps and continual sanitation efforts by maintenance staff of the dumpster on the ground floor have been observed by myself as recently as September 2025. Number 3, per amended appeal document dated June 9th, indicated as number 5. The relief I seek is this is Sally's number 5, the appellant. The relief I seek is the removal of any suggestion that I, a tenant who has lived in apartment 806 on the 8th floor of this 14-story building since November 2015 and never had any rodent, bedbug, or cockroach infestation in my 1-bedroom apartment for 8 years, was somehow responsible for the rat infestation anywhere in the building. I also seek reversal of and that the purported denial of my relocation benefits is the unsubstantiated, unattributed, but factually unsupported conclusion that code enforcement staff has determined based on visual observations that the responsible party has failed to maintain the structure adequately and the tenant is ineligible. Be set aside to the extent it refers to me, as the owner is responsible party for the rat infestation of the entire building according all the cited laws and other provisions of California law, particularly the Health and Safety Code. No justification for denial of relocation benefits has been established. Any statements, conclusions, opinions, or other factually unsupported matters must be by law set aside as unjustified because only the owner is at fault. As the person responsible for extermination of any rodent or other pest infestation, property owners are responsible for the maintenance of their own properties. This argument is considered diversionary and irrelevant. Furthermore, the appellant's claim of unsafe conditions on their property contradicts their initial assertion that the premises are fine and safe for occupancy. The city's position. This is inaccurate. With code enforcement cases dating back on the unit in 2022, CE 22-0803, one for pest infestation and a second case in 2018, CE 18-1024, with a water leak as the primary investigation and a second follow-up violation for trash and debris throughout unit. The flooding repairs were resolved under permit B19-3844, which was finalized. The work performed followed all best management practices and city policies. Lastly, to reiterate, the current update is the appellant is legally evicted, which is a landlord-tenant issue of which the city is not a party to. Additionally, pest extermination is currently on hold while Bethlehem Tower coordinates a time for the appellant to collect her belongings. To date, as recently as September 2025, the unit was still vacated, violations unabated, and extermination efforts are unable to be completed until the unit is clear of all hazards. I'm almost done. Okay. Just in summary. The attached documentation and images clearly demonstrate that the premises were legally uninhabitable and that the property's condition constituted an unmaintained public nuisance at all times relevant to the case narrative. The code references that have been provided support the city's position that the May 2025 issuance of a notice in order to vacate was both proper and necessary given the facts surrounding the premises. The city contends that the appellant's arguments are factually incorrect and wholly insufficient to overturn the issuance of the notice in order to vacate, and further, to change the eligibility of relocation benefit. Lastly, the appellant has been legally evicted and the city is awaiting an update from Bethlehem Tower regarding clearing the debris from the unit before extermination can commence. In consideration of all of the above, staff requests that the Board of Building Regulations Appeals reject the appellant's claims and uphold the action of the city in posting the premises as uninhabitable and deeming the relocation benefits as ineligible. And that concludes my presentation. Thank you.
Does the board have any questions of about the presentation?
Well, not at this time.
So, so now we have, the appellant, Sally, who is, going to voice her appeal to this matter.
Okay, first of all, this is a picture of how the rats first got into my apartment. During 2012 renovations by minor properties and associated multiple LLPs and so on. They replaced the light fixture and left a gaping hole in the drywall in the bathroom through which a rat could easily enter, because the rats live inside the walls. You can hear them running across the ceiling at night. The extermination expert has been observed on a ladder on the first floor, lifting whatever these are called, these panels, and placing rat traps above them, because the rats are throughout the entire building. There was apparently no attempt to rat-proof the building during the 2012 renovations that were paid for by city bonds. And the purchase, I believe, was made with a state mortgage that was forgivable. And the cost of the purchase was depreciated 9% a year for 10 years. So the developer, Reiner Properties, made a lot of money, and it was paid for by the people of the city and the county and the state. I would not put very much credence into anything that this licensed exterminator has to say. If you review the requirements for obtaining an exterminator's license, it is principally about how to use toxic chemicals, primarily to get rid of insects in agricultural circumstances. He has no particular understanding or knowledge of how to exterminate rats from a 14-story apartment building. And passing out a few rat traps with a mound of peanut butter in them does not get rid of the rats that are living inside the walls. I periodically would have electrical outlets stop functioning because the rats are inside the walls and chewing on the wires. It's a fire hazard along with everything else. I've seen rat droppings in the cabinets where cable and phone and so on, vendors come and, establish service. And on multiple floors. I spoke to a woman who was moving into an apartment on the 14th floor, and I said, do you know about the rats? And she said, no, and she was aghast. Nobody told her anything when she was signing her lease that there were rats in the building. And then the next time I saw her going down the elevator, she said, yes, there were rats in my apartment. So they don't do any rat proofing between tenants. They don't even pull out the stove to find out if there are holes in the walls where the rats are gaining access to individual units, until they make the effort to actually get rid of the rats inside the walls that can easily chew through the drywall and you're not going to get rid of the rat. And only giving out rat traps for tenants who complain is not getting rid of the rats inside the building. And we're talking about elderly and disabled people, many of them, in wheelchairs and with walkers. These are not people who can be chasing rats around their apartments, with traps and so on. None of the statutes cited in the report, and particularly Health and Safety Code section 116125 through 116170, those health and safety code sections put the responsibility on the city and the county if the property owner will not exterminate. And that's the situation we have here. I went to the citizen portal for the code enforcement department. And I looked through complaints at 201 Tupper Street, which is where this building is located, this 14-story apartment building. And there were rat complaints that preceded Reiner Properties purchase and renovation. And not all the, there weren't consistent, every year complaints, but there were complaints. And I have an article that I wanted to share with you. It's from the Press Democrat. That talks about how that there is no pre-inspection for this kind of a problem by code enforcement. They have to wait for a complaint to come in from a tenant. And I've talked to many tenants in the building, and nobody knows anything about how you make a complaint to code enforcement. And I've had to give them, information, give them forms. The fact that there aren't more complaints is simply because of the lack of knowledge of the tenants of their rights and the concealment of the rat infestation and other problems by owner and management. So I'm going to share this with you. I have a copy of my amended appeal and my request for reasonable accommodation in response to the notice to vacate. As the code enforcement officer mentioned very briefly, there were problems with flooding in the apartment twice in 2018 in October and November, and then in May 2019. There was flooding that came out from the walls into the hallway, flooded the carpet, and I was excluded from the apartment for a month. The repair was supposed to take a week or 10 days. Well, I was excluded for a month, and afterwards I made a Freedom of Information Act request. I guess there's another name for it in the state of California, to get copies of the records that were created during that 1 month repair in response to the notice of violation issued by the code enforcement officer. And by the way, between October, November 2018 and May 2019, I asked the maintenance employees, well, what's causing the flooding in my apartment? They say, well, we don't know, so we can't do anything. That kind of, the hiring of handymen is not sufficient to eliminate a problem that is going on in the building. And Uella Lawson, I think is her name, came to the building when John Stewart Company first became the property manager. I'm not sure of exactly when it was. It was in 2019. And she said, we realize we have a lot of plumbing problems in this building, and we're going to try to fix them. Well, after I was excluded from the apartment and I got the records from the code enforcement, they had hired a painter decorator to make the plumbing repairs. Obviously, a painter decorator is not licensed to perform any plumbing repairs. There was no attempt to make any plumbing repairs. And so I then had another flood in 2020, about 19 months later. I made a report. It's not even accessible in the citizens portal for code enforcement because I looked through it. And it's apparently because code enforcement was so busy at that time with so many complaints that it took like a week or so for the code enforcement officer to come to my apartment. And by that time, the flooding had dissipated and the carpet was dry. But I had a flood, it was acknowledged by management. And, you know, obviously it was never repaired. I have no tenants have no responsibility to exterminate. I have provided pages from Bethlehem Tower House Rules effective date 11/1/18 that talks about, and I'm focusing on community safety and care. And there's no smoking on the property. Well, I've made complaints and others have made complaints, and the smoking never stops. Pest control. A professional pest control service will be provided at the property. Well, he passes out snap traps. Anybody can go buy snap traps, but that doesn't get rid of the rats in the building that are ready to chew their way into every apartment, because there's no rat proofing. Units will be treated for pest control. Well, that's not enough. You can't just treat the units. You have to go inside and find where they're living. My research reflected that there is a pest control service in New York City where they have the storied problems with rats. And they acknowledged what the code enforcement officer told me and now doesn't remember, that they get in through the trash chute and climb up the trash chute, which goes to every single floor. And then they can find their way everywhere throughout the building. In New York City I found a pest control operation that was able to remedy this exact problem. You have to not just put rat traps in the apartments, but you have to go up where the rats go and find where they go. Until then, the rats will always be there. Tenants have no responsibility to exterminate. They have a responsibility to notify. I began notifying management in January 2014 that there were rats in my apartment. I lived with those rats for over 600 days. And instead of getting rid of the rats, because passing out snap traps is not enough, they evicted me unlawfully, totally unlawfully, never served with summons and complaint. I never got any notice until the sheriff's notice was posted on my door. I had 6 days before they were going to put me out. And why did they do it unlawfully? Because this entire process with my appealing and making a request for reasonable accommodations put the code enforcement department on notice that there was a problem. And as the code enforcement officer has acknowledged, there was a problem, and it was the responsibility of the owner of the building. And they cannot evict within 6 months of a complaint to code enforcement. Well, obviously, they couldn't evict me lawfully, so they had to pretend that they had served me. They didn't serve me. They entered a judgment against me by default. I'm a lawyer. I don't ignore summons and complaint. I was never served. I was simply evicted unlawfully. And there are many other defects in the complaint. And it's on appeal. In the meantime, you all have great advantage over me because I have been homeless for almost 2 months now. And they locked me out for 9 days without even a toothbrush or a change of clothes. And it was done so cruelly. I have never seen such a cruel eviction as they visited on me. And they had 2 or 3 people standing there watching me when I was trying to collect a few items. You know, I was trying to get my computer so I could continue to do my legal work. I was trying to collect a few pieces of clothing, you know, my files, my paperwork that I was denied access to for 9 days when they locked me out. So, you know, mold notification. There was standing water in my apartment in May 2019 for over 72 hours. There's a notice attached to the lease. It says you have to notify us immediately. Well, because it was over a holiday weekend, they did nothing for 72 hours. And that's why when the code enforcement officer came to my apartment, she could see the water, the standing water in the apartment, which leads to black mold. There's black mold in the apartment. I was living with black mold in the apartment. They did nothing about it. They said, well, it's not our fault. Well, the problem is that when they excluded me from the apartment actually it was in July. The flood was in late May. I was excluded from the apartment in July for a month. They packed up all the stuff in the bathroom, the kitchen, the hallway, the closets, and put it in boxes. And they turned my apartment into a storage locker. That's how all of this clutter originated. And they told me, these two young people, much stronger than me, much younger than me, they told me, we can come back and help you unpack. Well, they never did. And I kept writing to management, when are you going to help me? You know, I can't organize I can't put anything out in the hall. They denied me the right to put things out in the hall so I can organize. They stacked the furniture and everything up in piles. And that's why you see, you know, these piles of things. You know, there's all this talk about rotting garbage. I don't see any rotting garbage in any of these pictures. Sure, there's clutter. But if you have rats, if you've been living with rats for over 600 days, they are quiet. They are noiseless. They run up the walls. They jump from floor to ceiling. They throw everything off the bookcases. They invade everything. I couldn't even get into one of the closets because they had turned it into their nest. And I wanted to know where they were. So there were things on the floor that made noise when they were running around. And so I knew where they were. I've been bitten. I was bitten by the rats. I was scratched by the rats. They would jump on me in my bed. And I wanted to know where they were. I was protecting myself against the infestation. So the clutter had a purpose. I was doing all I could do under the circumstances. So you can see that I had no responsibility other than to report. I had no responsibility to exterminate. So here code enforcement's about requests about the floods. Here's a letter from Peggy. She was, when I first moved in, she was a secretary, and she wrote a letter of complaint when she resigned in August 2019 about the serious problems with management, taking advantage of and blaming tenants instead of keeping the place clean and maintained. I wrote in January to I fell in May 21, 2022. There was a release of high pressure water from a sprinkler, a fire sprinkler, and it flooded the third floor down to the lobby. And there was no warrant, you know, I live on the 8th floor. I was going down to find out why my friend's car was parked askew in what used to be a bus stop in front of the building. And I pressed a button, the door opened on the 8th floor, and I stepped in, and immediately my foot slipped out from under me and I fell hard on my back. I suffered an injury to my right shoulder, which required surgery. I wasn't able to use my right arm for any lifting for like 6 months. And then the rats invaded. During those 6 months, there was very little I could do. You know, I was able to survive. I had an electric can opener so I could open cans and feed myself, but I couldn't be doing, you know, heavy lifting and reorganizing. I was told by my doctors to keep my arm in a sling. And so for those 6 months, I wanted I was warned if I didn't baby my arm, the repair would fail and they would not be able to fix it again. I wanted the use of my arm back. So forgive me for not being a good housekeeper. So I wrote him a letter about all that, and I told him about the clutter that stemmed from 2019 when everything was boxed up and piles of boxes were left in my apartment. So this is a September 18, 2023 letter to the assistant manager. January 22, 2024, I wrote to him, Zebedee Kiriowa, that the apartment was untenable under state law for which the landlord is not entitled to rent. I went to him and I showed him my backpack that had been chewed into by the rats, and they had eaten the corn that I had bought the night before. I came to report that I had rats living in my apartment and needed some rat traps. Instead, he wanted to talk about paperwork that was late or something that I didn't know anything about. And he chased me out of his office instead of acknowledging the problem with the rats. He knew about it. He just wasn't gonna talk about it. Oh, rats to roaches, the guy who wrote the report that said it was a horrible mess and that was all my fault. Once again, he has no special training in how to get rid of rats in a 14-story apartment building. I told him, he entered my apartment to spray for, I guess it was fruit flies or something. And I told him there are rats running at night. You can hear them running around on the ceiling. And he said, oh, nothing to worry about. He didn't care. Oh, he came in, he was going to spray treatment for the rats. That's like crazy. You don't spray for rats. You don't spray poisons in an apartment. Anyway. Okay. I got a letter from Suzanne Wilson. She's the highest ranking John Stewart company. They're the management company. They're the people that live in the offices on the first floor. She's the highest ranking person on the premises. And so she wrote me this inventive letter about how it was all my fault. So I asked her to answer these questions, which she never answered. How precisely do you think the rats got into my apartment? And these are things that you all should be thinking about. Number 2, what has the landlord or his management team done to rid the entire building of rats and other infestations living in the filthy space between the walls and ceilings of this building? There is constant filth coming through the so-called vents in the kitchen and bathroom. It is dirty and greasy from the inhabitants of the between wall spaces. Don't forget, I live on the 8th floor. 3, do you really think that rat traps set in individual apartments will rid the entire building of the infestation between walls and floors and ceilings in all 14 floors of this building? 4, when was the landlord or his employees, agents, representatives, or many layers of management first aware of the entire infestation of this building by
I'm
insect
going to
and
interrupt
rodent
really
pests?
briefly, but you have a minute and 25 seconds. But
Because their first knowledge is supposed to trigger their extermination efforts. And then here is kind of an accumulation. This is a letter to Mary Nunez, September 25, 2024. And it has copies of my complaints. I noticed that the code enforcement officer said nothing about her job as health officer. Because there is no health department in the city of Santa Rosa, someone at code enforcement fills in that job, health and safety. And that's why I think it's so important for you to consider the, I mentioned it earlier, it's in my in my appeal. Health and Safety Code 116125 and so on. Because that puts the responsibility for eradicating an infestation on city government, and then they can put a lien on the building when the landlord won't do it. And that's the responsibility of the health department, and that would be the responsibility of, I believe, this code enforcement officer, and
Okay.
she didn't even
So
mention
your
that.
time is up. So, now we're gonna open questions and comments from the board. Do we have any board questions to the appellant?
No question to the appellant, but I have a question to staff and to the city attorney.
Okay, go ahead.
The city attorney, she indicated that the city has a responsibility for rodent infestation. Are you aware of any responsibility existing?
No, I'm not aware of anything in our code or within the California regulations that puts the onus on the city.
Okay. Code enforcement officer, would you state again what the unsanitary conditions were besides rodent excrement?
Yes, so there was a foul odor trickling out, a foul odor detectable on the entire 8th floor. So when you disembark from the elevator onto the 8th floor, you can immediately smell the odor of rotting food or trash. The trash was piled high up against the walls. There were egress issues within the unit. There was one clear path through the front door to the slider, but the room was not accessible. So meaning that a journey couldn't pass through, you couldn't fully open the door. That is a violation of city code. You need a clear path of travel and egress.
What were the other anomalies that be like bed bugs or something of that use?
So fruit flies,
Okay,
so the exterminator discovered cockroaches, fruit flies, and obviously rats, rodent infestation. They stated potentially bed bugs. I asked the appellant, have you noticed or observed any bites on your person? I did not inspect for bed bugs. I observed directly rat droppings, and I observed the fruit flies, and I observed fecal excrement along the walls and along the smoke detectors and other places like that.
So, all the questions?
that's all my questions for
Any
staff.
questions for anybody else?
I was thinking similar questions, so they got answered. I'm okay.
Oh, I'm sorry. One more thing that I think to your question. I also called out the fact that the bathroom and the shower was not accessible. Per the health and safety code, you have to have access to all plumbing facilities, and the oven wasn't accessible as well. So there were some other health and safety sections that were in violation, but primarily the notice in order to vacate was for the sanitation and infestation.
I do have one more question for the city attorney. The appellant made a comment that a code enforcement officer has to be a health and safety officer. Is that true?
Not that I'm aware of. I mean, the county has the health department for the county. As a city, we don't have our own health department, but they don't act as a health officer.
Did you cover, can you just summarize again the two decisions that are in question? That they will either uphold or?
Yes.
deny? We could do, yeah, either way. I don't know.
Well,
if that would be helpful.
let's go ahead and open this up to any public comment in the room. Is there anyone here to have any public comment?
I would quote from,
So
So you're not, this is separate. The public.
I'm a member of the public.
if there are any members of the public who are in the room
Yeah,
who wish to
check them first.
speak, please raise your hand. Seeing no members of the public wishing to speak, Chair?
Okay, so we see no closing public comment for other people in the public. Are there any final questions or comments from the board for staff? You can, we can go like for another minute if you've got a question.
Okay. Again, it's Health and Safety Code 116125 through 116170. I would suggest that the deputy city attorney look it up. It requires property owners to take immediate action to exterminate and control rodent infestations upon discovering their presence. Not waiting a couple of years and passing out a few rat traps. And it goes through the process of if they won't do it, then the city or the county steps in, takes care of it, and then puts a lien on the property and that sort of thing. And I would be happy, I would be happy to provide a supplement of 1 page citing these health and safety code sections and pointing out how in the absence of a health department, the city appoints a code enforcement officer to be the health department, more or less. I don't have it committed to memory. I'm 74 years old. I remember a lot, but I don't remember all these details, but I'd be happy to put a 1-page supplement together so you can see what that's all about, because rodents are a health and safety problem. They carry disease. If you go to the CDC website, you're supposed to wear an extensive mask, protect yourself, because the urine, which is what that smell
The
is.
time is pretty much up, so. thank you.
Okay,
All right. So you wanted to do a clarification of the questions that were decided.
Yeah, just to help you guys make a motion one way or the other.
So my understanding of the appellants is to, 1, uphold the notice and order to vacate in its entirety, and the request that the city overturn eligibility for tenant relocation from ineligible to eligible.
So to clarify, the notice to vacate is my decision that you would be upholding or denying or overturning, I should say.
Okay.
So,
And that is connected with the compensation.
yes.
Okay.
It is true that she's been evicted, correct? She does not live there any longer.
Correct.
Any further questions from the board? All right. So we are now at the board decides what's going to go. Questions, we know what the questions are. Is anyone prepared to make a motion for us to proceed?
Craig, you've got your notes.
Lots of them. I would make a motion to uphold the eviction.
It's not, no, the notice to vacate.
Notice to vacate.
So try it again.
Yeah. I would make a motion to uphold the notice to vacate. And I could cite a lot of
Well,
reasons
okay,
why,
so
but
is
I'm
that
not going
is
to.
that your motion?
Yes,
Okay, so we have a motion on the floor to uphold the motion to vacate.
I'll second the motion.
Okay, now we can have discussion of the motion amongst the board. Do we have any discussion of this motion?
I'm good.
Okay,
I'm good.
all right. Hearing no discussion, I'd like to call for a vote. Could you please reread the motion?
Thank you, Chair. The motion is to deny the appeal tendered by Sally Steinhardt and uphold the staff's issuance of a notice in order to vacate. So starting with roll call.
Well, that's okay, so that's not exactly what he said. Is that
That's fine.
okay? So that's what everybody else is understanding the motion. Okay. Go.
Board Member Gordon.
Aye.
Board Member Miller.
Aye.
Vice Chair Lawson,
Aye.
Chair Cooper.
Aye.
That motion passes with 4 ayes and passes.
Seeing no other items on our agenda, I'd like to say that this meeting, for voting regulations appeals is now adjourned.